Good evening. This is the December 17th, 2013 Constitution Meetup in Austin, Texas. I'm Jon Roland. Today is our last day meeting at the Old Quarry Branch Library in North Austin. Beginning in January, we will be meeting on the fourth Tuesday of each month at the North Village Branch Library on Steck Avenue. Except that in November and December of 2014, we will be meeting on the second Monday of the month in the same library. The theme of this meeting, since Sunday was Bill of Rights Day, is the Bill of Rights. And I'm going to examine some of the things that make the Bill of Rights important and may make it necessary for us to expand on them. Now, to go over a little history, originally the Constitution on September 17th, 1787, was proposed without a Bill of Rights. There had been an English Bill of Rights adopted as an act of Parliament, which served as a model. Several of the states, especially Virginia, had adopted a Bill of Rights in connection with their constitutions, their new state constitutions, on which the federal constitution was modeled. So there had already been established a history of listing rights. A bill means a list, and the list of rights, the Bill of Rights, was supposed to be restrictions on the powers of government. Now, the omission of a Bill of Rights from the original Constitution was not an oversight. Many of the framers of the Constitution thought it was unnecessary, that they simply had not delegated the powers to infringe on rights, and therefore it would be redundant to try to list any rights that, were restrictions on what government could do. The arguments made are summarized down here, that a Bill of Rights were unnecessary because no powers have been delegated that might infringe on them. Now, Madison also argued that declared rights are mere parchment barriers that can only be protected by constitutional structures that divide power among contending forces. In other words, he was a great believer in separation of powers. Third, the argument was made that listing all rights was impossible. They were infinite. And it would be dangerous to provide a partial list because any omissions could be interpreted as those rights not existing. Under the common law rule of construction called expressio unius est exclusio ulteris. In other words, if you don't express one, then it's excluded as an alternative. Now, some of the framers, like George Mason, refused to support the ratification of the Constitution without a Bill of Rights. And a lot of people agreed with them on not to ratify the Constitution on those grounds. So a Bill of Rights of some form became a leading subject of debate over ratification. And the way it was resolved was that the leading proponents of ratification agreed with the opponents that that once the Constitution was ratified, they would adopt amendments that would add a Bill of Rights to the Constitution. And it was on the strength of that reassurance that they proceeded to get enough support for ratification. And ratification was achieved June 21st, 1788. Each of the ratifying state conventions had adopted a list of amendments they wanted to see made. Most of those having to do with rights. So after a ratification was declared, Madison was elected to the House of Representatives in the first Congress. And he was generally agreed, had the unenviable job of trying to boil down all of the proposed amendments that had come from all of the states and to try to come up with a shorter list of constitutional amendments. Now, he did that. He came up with a list which he proposed in the House of Representatives. The House assigned it to committee where they boiled it down some to a shorter list, consolidated some of the amendments. Then the Senate took it up, assigned it to a committee. They further boiled it down. It went back and forth, and finally they agreed on a list of 12 amendments. The first two of those were not immediately adopted. In fact, one of them was finally adopted in the 70s, but after almost 200 years. But the amendments 2 through 12 became known as the Bill of Rights. Those were the first 10 amendments. The Bill of Rights, by the way, is not an official title of the amendments. It's just what people call them. Now, we have a page on our website at constitution.org called The Documentary History of the Bill of Rights, which you are welcome to visit. It starts with a table of the sources of the Bill of Rights, which is interesting because it shows for each of the Bill of Rights where it came from. It's in a table, and what I do here, I have numbers across the top, numbers down the side. Down the side are the rights that the states or others call for, and the numbers across the top identify the source of it. So if we go down to the bottom here, we'll say like number 3 was one of them proposed by Madison. Number 4, Madison numbers as it proposed to Congress. 5, adopted by Select Committee. 6, adopted by House of Representatives. 7, adopted by Senate. 8, adopted by a conference and Congress was sent to the states. 9, ratified. Then we go down to the English Bill of Rights, the Virginia Bill of Rights, the Virginia Convention Bill of Rights. In other words, that's not just what was in the Bill of Rights that Virginia had adopted for itself, but the Bill of Rights that the Virginia Convention proposed to the federal government. And then it has each of the other lists of proposals: Pennsylvania, Massachusetts, Maryland. And actually, there are two groups from Maryland: the Maryland majority, the Maryland minority. There's also a Pennsylvania minority report. South Carolina, New Hampshire, New York, North Carolina, and what we did is prepare this table, and it shows where they all came from. They didn't all come entirely from the state ratifying conventions. Some came from other sources, but Madison thought them important. And but he recognized the problem that if you left any rights out, that people would try to interpret that to mean they didn't exist. So he proposed a catch-all amendment that essentially said that any rights that aren't listed here are to be recognized, but we just don't spell them out. Well, what Congress did is he split Madison's proposed amendment into two amendments that became the 9th and the 10th Amendments. The 10th Amendment had to do with powers. It essentially said that any powers not delegated to Congress or to the rest of the federal government were reserved to the states or to the people. In other words, this is sometimes called the non-delegation doctrine, or one of the forms of the non-delegation doctrine. If it's not delegated, it doesn't have the power. The 9th Amendment says there are unenumerated rights that we're not listing here, but there are nevertheless rights that are to be recognized. Now, what has happened in practice is exactly what the anti-federalists feared, because judges have taken it upon themselves to say that if they can't find a right spelled out, that they're not going to recognize it. And they're not willing to study legal history to find out what other rights might be included in the 9th Amendment. They're just not willing to do that. Neither liberal judges nor conservative ones. So we've had a problem with trying to get the courts, much less the executive branch or the legislative branch, to recognize unenumerated rights. And one of the things that I've done is try to find all the rights that I could that in historical record, going back to more than 1,000 years, all the legal authors that the framers respected, some of them even going back to ancient Greece and Rome, ancient Israel and so forth, and list them all out. And it's quite a few of them. I've got them here. We've got 15 in one group, 16, 17. We've got 10, 12 more there, and another 5 more here, and so forth. Under the other category, we go down to 14 of them. So we've got, or I've got, another 30 or 40 rights that can be listed out. And what I have proposed to do, first I proposed constitutional amendments that would spell out all of those rights. And secondly, I have proposed legislation, essentially an amendment to the Civil Rights Act, which would add recognition of all of those rights to the Civil Rights Act so they could all be litigated in federal court and enforced as criminal violations if anyone infringed on them who were represented an agent of the state government. Now, needless to say, if I could ever get that introduced in Congress, it would start a conversation. Right now, I have the usual problems of getting anyone to pay attention to it because I don't control a lot of money or votes. But one has to start somewhere, and I'm hoping that others will pick up on this and carry it, make it an issue in their campaigns, perhaps introduce it in Congress, and so forth. Now, what is it about a Bill of Rights that is important? Why was it a good idea to adopt it? Clearly, the history of the Bill of Rights has been that most of the rights that it recognizes have been some of the most important cases that have gone before the federal courts, and particularly the U.S. Supreme Court. People know the Bill of Rights better than they know the Constitution, because for one thing, they're more likely to litigate over it. So it has certainly been important for litigation. But we can ask ourselves, if there had been no Bill of Rights, would we be any worse off? And I think the answer is yes. Because the reality of law, and constitutional law in particular, is that it needs to be specific as it possibly can be. The Constitution, as originally proposed, was only 4 handwritten pages. To be as specific as I am proposing in my proposed amendments and my proposed expansion of the Bill of Rights, it would run to more like 40 pages. And some would argue that to be as specific as it would need to be, it would need to be 400 pages. Well, the reality is that if it had been 40 pages at the outset, it would never have gotten ratified. It needed to be succinct. It needed to be concise. It needed to be expressed in as few words as possible. But brevity is in conflict with specificity. And it is specificity that protects rights. When you try to boil down rights protections in a language as naturally vague as English is, and legal English in particular, you are going to introduce vague language that is too easy to find loopholes in, to find excuses in to violate those rights. I see no real way around that. I have made many attempts over the years to try to find better language for what is already in the Constitution, and the only thing I've ever been able to find that more adequately protects rights is a lot more specific. So for those who argue that the Constitution and Bill of Rights are just fine the way they are, if we would just interpret them properly, well, I'm sorry, but I engage in debates every day with legal scholars, and they're unclear. They're some of the best educated people in the country, and they can't agree on what our rights are, on what government powers should be, based upon what's written in the Constitution. So unless we can make the Constitution a lot more specific, we're not going to be able to rein in powers or protect rights. Now, some of that can be done through legislation, as I have proposed to do. We can approach it from many different angles. But whatever we do, we need to get down to specifics and stop wasting our time with broad generalities that don't get us anywhere. There are many discussion groups out there that essentially waste their time arguing about broad, general, vague, aspirational language that, even if adopted, wouldn't help us because it is not specific enough to protect against attempts to misinterpret it. The way to avoid misinterpretation is with specificity. That's how contracts that start out being one-page documents wind up being 100-page documents. It's not because the lawyers just like to cram a lot of legalese into the document so they can run up their bills. It's because over a period of time, we have discovered the hard way that if you don't cover every angle, if you don't have language that allows for every possible misinterpretation, that somebody is going to find a way to misinterpret it. So specificity is critical. Now that we have had another Bill of Rights Day, we have had celebrations this year all over the country, more than in any previous years. We've had many more hits on our website as a result of that, and that's great. But now we need to continue it. It's not enough just to study it or discuss it. We need to get down to specifics. And that's going to take groups meeting like us to hit our members of Congress, our state legislators, our opinion leaders, anybody we can find, and to keep hammering them with, demands that they support our specific language of reform. Not their language, not something they might come up with, but our language. Because, as I'm fond of saying, if you demand something of others without being specific, you're not asking them to do something for you, you're asking them to do something to you. We have to write the language. We cannot depend on others to do it for us. And if you don't feel that you're up to writing the language, that's fine. I've written plenty of it for you. Now, you might have trouble understanding initially why it's important to write this much stuff in the way that I have. Fine. I don't claim to have perfect solutions, but it's enough to get started. If this were to be introduced, no doubt there would be plenty of debate, and some of the debate might result in improvements. But you have to get started somewhere with something, and you don't want to waste a lot of time nitpicking on flaws you might find in it, just before you even get the discussion going, before you get the debate going. So the key thing is we need to get the debate going. And to do that, we need to have specific proposals. Now, some specific proposals are not that great. We've had some from Randy Barnett, a friend of mine. He's a great guy, good constitutional scholar, but his proposals weren't that great. We've had another set from Mark Levin, which has been getting a lot of attention. But his aren't that great either. His intentions are good, but the way he has designed his amendments, they just don't do a very good job of solving the problems he tries to address. To understand why requires a lot of discussion in itself. But whenever you see proposals like that, you have to ask not only how they would work if they worked right, but also how they could go wrong. So you have to examine each and every one of them for all the ways they could go wrong, all the ways they could be misinterpreted, all the ways clever lawyers could try to distort their meaning. You have to really think ahead, to not only think like a lawyer, but think like legions of future lawyers. And that's not easy. It's not easy for the lawyers we've already got. There are probably not 200 people in the world today who have the knowledge and skills to amend the U.S. Constitution. And probably, if you got them together in one place, they'd have 300 different ideas for how to solve the same problem. So, to assemble those with the knowledge and skills and also get them to talk about it long enough that they can begin to reach agreement is then the great challenge. And if I could do so, I would try to organize a series of working meetings to do just that. But of course that takes money, takes backing, and I don't have enough of that right now. So anyway, for those of you who view this video, those who couldn't make it to the meeting tonight, I urge you to spread it widely, to urge people to view it, to talk about what I'm discussing here, to go to my website, constitution.org. You can find the link at the history of the Bill of Rights and the Constitution blog. All the links, to this material are on the home page. Not hard to find. And if you do that, you will eventually get these materials and you can begin to work on them. So with that, if there are no further questions, I'll call it a meeting and look forward to seeing you next month on the 4th Tuesday at the North Village Branch Library. Good evening.